In today's video, we're talking about the Scottsdale City Court, and in particular, we're talking about DUI cases. If you've been charged with a DUI out of the Scottsdale City Court, what is going to happen at your very first court date? It's called an arraignment. Most people have a lot of anxiety about what their first court date has to hold for them. They're concerned that they're going to go to jail that day, they're going to get sentenced that day, that there's going to be all these penalties imposed on that day, when in reality, it's not as complicated as it may feel, it's not as scary as it may sound. What happens at an arraignment, so if you go into Scottsdale, you're going to check into security, you're going to go sign in, you're going to go into your particular courtroom, and you're going to be sitting in a courtroom with a lot of people charged with a lot of various different crimes. So not particularly only DUIs, but you may be in there with somebody with a DUI, somebody else with a domestic violence charge, somebody else with an assault charge, and a number of other different charges. Now, what the judge will then do in some cases is do what's called a group advisement. They'll go through and they'll tell you and they'll say, if anybody's been charged with a DUI, these are the maximum penalties that are associated under the law for a DUI. And you're going to hear the judge say something more or less along these lines. The maximum penalty is 6 months jail. The maximum fine is $2,500 plus surcharges. You could be on probation for 5 years. You can have collateral consequences that are going to impact your driver's license and immigration consequences and all sorts of different things. Some judges out of Scottsdale do it a little bit differently. Some follow it by the book. It's very rigid and they just run through all of the maximum penalties. Some of them are just kind of ad-libbing it. They just kind of have their own version of those penalties. But the point being is that they tell you what the maximum penalties are. Now, just because the judge says that you could theoretically go to jail for 6 months doesn't mean you're going to get that. The judge may also read some minimums, tell you what the mandatory minimums are. But the whole point of the arraignment is to just advise you of what you're facing. The arraignment is to inform you about what the charges are and what the penalties are, because you need to know those things in order to make decisions about how to proceed in your case, whether you should plead guilty or not guilty, whether you should hire an attorney, whether you should set your case right to trial. There are a number of different options that you need to be considering as to whether you're going to make them or not. And you can't do that unless you know what you've been charged with and what the penalties are. So once the judge does that advisement, if they do an advisement to the entire group, then they'll start processing people one at a time. So they'll call somebody up, they'll say, okay, you're here, they'll call your name, you'll go up in front of the judge will officially tell you what you've been charged with. If you heard the advisement, the judge may say, do you have any questions about it? If you didn't hear the advisement, the judge will tell you exactly what the penalties are as they relate to your particular crime. Now, at the arraignment, this is not a good time for you to explain yourself or to ask questions about, hey, if the officer didn't read me my rights, what should I do? Those are not the appropriate questions at this time. The judge's real only concern is to what to do with your case on this particular issue. Do you want to plead guilty or not guilty? If you have questions about what the difference is, the judge is probably just going to enter a not guilty plea for you and then give you a new court date. The judge also wants to make sure that release conditions are addressed. So if there's anything that's preventing you from being released on your own recognizance, meaning that you're out of custody and you're not checking in with somebody, the judge may address those. The judge may also want to talk to you about legal counsel. If you're facing a DUI, there's mandatory jail for all DUI charges. If there's jail involved, you're going to be potentially eligible for a public defender. If you don't make enough money to go hire an attorney or to contribute, then what the judge will do is appoint you somebody who works as a contract with the city of Scottsdale to represent you throughout the DUI case. If you make some money, the judge may ask you to contribute to your defense. Otherwise, you may just be appointed a public defender. But that's really about it. There's not a whole lot more that goes on at your first court date for a DUI in Scottsdale. Really, the judge is going to tell you what you've been charged with. Make sure you've got representation or a plan in place for that. Or if you can afford an attorney but you don't want one, you're free to represent yourself. You just need to go speak with somebody like us who helps people through DUI cases. And then the judge will almost always set a new court date. It's going to be called a pretrial conference. We call them PTCs. It's usually going to be in about 30 days or so. You may be in a different courtroom. So if you're in a courtroom 5 or courtroom 7 or courtroom 8, they may assign you to a different, more permanent courtroom, like courtroom 2, 3, or 4 in most cases, where you'll have an associate judge or a presiding judge who's going to be handling the case for the rest of the time. So that's what happens at an arraignment. Not super scary. You really are not going to be taken into custody in 99.9% of cases if you're out of custody already. This is something where you can just go and get the lay of the land, find out who your official court is going to be, what official courtroom you're going to be assigned is, and you may have an opportunity to speak with the prosecutor or somebody who is basically a prosecutor's assistant, a legal assistant. They may have a plea agreement prepared for you that you can review and sign. That doesn't always happen because sometimes they don't actually have blood results back yet by the time you go to your arraignment. And so they'll just basically tell you that they've got nothing for you at that time, and then they'll wait for you to get rescheduled for a pretrial conference. Then when you come back in about 30 days, if you're representing yourself or you have a public defender or you have a private attorney, you may not need to come back at all. If you do hire a private attorney prior to your first court date, you do not have to go to your first court date. So one of the main benefits of hiring an attorney is that you don't have to go to all these court dates. You let our team do that. So we go for you and we speak with the judge, we speak with the prosecutor, and actually vacate the arraignment and get you scheduled for what's called a pretrial conference, and then we attend that court date and really most of the other court dates for you. So I hope this helps. I really don't want you to be too nervous about what happens at your first court date. It's a pretty straightforward process. There's not much that you're going to need to be speaking or saying to the judge or to the court if you're going to be going on your own, other than being prepared to talk about your financial situation, whether you need an attorney, whether you're investigating hiring an attorney, and really whether you intend to plead guilty or not guilty. It should almost always be not guilty, just because of the fact you don't have any evidence yet. You don't have police reports, you've not done your interviews, you may not even have blood results yet back. So you want to plead not guilty, and then we can start investigating the case further. But it's pretty basic court date, not too much to fear. If you have any questions about it, if you have any concerns, if you're concerned that you've been charged with a DUI, you want a little bit more information about how it works, give our office a call. We're located literally 5 minutes north of the Scottsdale City Court. We put our office here for a reason. We're there in Scottsdale all the time. We have a great track record representing people on DUIs and all sorts of criminal cases. So there's literally nothing to lose. We'll give you some guidance, give you some insight, walk you through the process. That way you're not going in blind, you're going in with a team who can help you through it and make sure you get the best possible outcome. So free case evaluations, nothing at all to lose. Give us a call. We look forward to speaking with you soon, and thanks for watching.